Hi everyone, welcome to this week's OJO Q&A, where, as you might have already seen on our social media, our topic is party to a crime. Joining us again is probation and parole agent Kim Malone from Reality Check by Kim. And from our very own office, joining us is Attorney Ohiku and Attorney Patterson. Welcome everyone. So last week we discussed being arrested, criminal background checks, and criminal records, and that transitions nicely into our topic of party to a crime today. So first, let's talk about what being a party to a crime means. So Attorney Patterson, can you give us a brief definition of what it means to be a party to a crime?
Yeah, so party to a crime in Wisconsin is defined in the statutes 939.05, and part of it says whoever is concerned in the commission of a crime is a principal and may be charged with and convicted of the commission of the crime, although they did not directly commit it. In Wisconsin, concern in the commission of a crime can mean three different things. One, they directly committed the crime. Two, they intentionally aided or abetted in the crime. Or three, they are a party to a conspiracy.
Thanks, Attorney Patterson. Attorney Ohiku, in your experience as a defense attorney, can you think of any specific challenges that party to a crime charges may bring?
In terms of challenges?
Mm-hmm.
No challenges. Prosecutors, they love party to a crime, right? They love party to a crime. They love the bell jumping statute because they're very easy for them to prosecute. Party to a crime basically means if you were with someone, you could be charged with whatever that other person did. And then we got to remember, that's just the charging part. So the issue is, can they be charged? So yeah, a prosecutor can charge two people. If one of the persons went in and did something, they could charge the other person because the statute says that if they're with someone, they could be charged as if they are the principal. So no, I don't see any challenges or issues with the party to a crime statute.
Interesting. Kim, in your experience as an agent, you've probably seen a lot of repeat offenders. Do you see a lot of that with party to a crime specifically?
Yeah, we do. And like Attorney said, that it's probably just that people are in the wrong place at the wrong time. And a repeat offender means that they keep doing the same thing over and over. And when they keep doing that, then it starts adding on enhancers and habitual criminality, in which means that even though it's a small crime, let's say of retail theft, if they continue to do it, then their sentences can be harder or more harsh or involve more things.
Okay. Well, now that we know what party to a crime is, let's look at some specific scenarios and see if someone would be considered party to a crime. So our first scenario, let's say I drove my friend to a gas station and he stole something. I knew that he robbed the gas station, but he never told me. I simply believed that I was giving him a ride as a favor, and I was surprised to find out that he stole something. Am I party to a crime if he gets caught? Attorney Ohiku, what do you think?
You're asking me?
Yeah.
Yeah, you're party to a crime, and the DA is going to say, "Yep, you're going to be charged with the party to a crime of robbery because you're with the person." Whether you all the essential facts that came with what happened, the prosecutor's going to say that you're there. That all of that other stuff will get sorted out. But yes, you will be considered party to a crime.
Okay, and Kim, you mentioned being in the wrong place at the wrong time. Is that what happened here, you think?
Yeah, I definitely think that unfortunately he didn't know who he was with or what kind of person, which is something I always talk to my offenders about, is making sure that you know who you're with and what kind of person they are, because you can get caught up in things.
Okay, interesting. Now change the scenario a little bit. I knew that I was his getaway driver and that he was going to steal something, but I never stole anything myself. Am I still a party to a crime? Attorney Patterson, what do you think?
Yeah, I would definitely say they're still party to a crime. Although they didn't know, they still, let them get in the car, drove away. So they're definitely aiding the person and robbing the store. So I would say they're a party to a crime.
Okay, now we're going to change it up a little bit more. Attorney Ohiku.
Well, you got to look at it from the outside looking in. If you saw that scenario, would you think the driver was involved in it? Probably, right? So I mean, that's how the prosecutor looks at it too.
Okay. Attorney Ohiku, changing the scenario a little bit. What if my friend runs away and is never found? can I still be charged with party to a crime if he's the one that actually stole something and he didn't get caught, but I did?
Yes, yes, you can be charged. Your friend doesn't have to be charged, could be charged, doesn't have to be charged. Yeah, you could be charged. Even if the prosecutor knew that you weren't the main, so to speak, actor involved, prosecutor could still charge you, and you could be convicted, for that crime.
Okay, change the scenario one last time. We both got caught. He's charged with robbery. I'm charged with robbery as a party to a crime. Do we face the same exact penalty? Kim, what do you think? Have you seen a lot of this in your experience?
I have, and yes, you can both be charged with the same thing. And I've seen instances where the person that's party to a crime has actually been charged more because they didn't tell the information. And a quick scenario was a guy's girlfriend was cheating on him. He told his friend that he was going to kill the guy the next time he saw him. Friend didn't know when, where, how, or anything. The guy ended up killing him. And the party to a crime, they're saying he was party to a crime because he knew that it was going to happen and he should have revealed that information. So he actually got more time than the guy that killed and had to pay all this restitution.
Wow. Attorney Patterson, do you agree? Same answer?
Yeah, definitely. They, obviously will face the same penalty at the outset, but like Kim just said, there can be differences in the sentence depending on how much, involvement each person had or, where they could have stopped someone else from committing a crime.
And what the person's record is, if they got a record.
Right.
Okay. So now let's go over a quick scenario that I pulled from my criminal law textbook. So here it is. Bill asks John to give him a ride to a friend's house. Bill says, "I'll be right back. Keep the engine running." It's 10 p.m. There are no lights on in the house. John watches as Bill walks to the front door, pulls a crowbar from his jacket, pries open the door, and enters the house. 3 minutes later, Bill runs from the house to the car with a laptop and jewelry. He tells John to drive off, which he does. Bill later gives John $100. Later, John tells the police that he had no idea Bill planned to break into the house until Bill pulled out the crowbar. Is John party to a crime? Why or why not? So what do we think? What does the answer depend on? Attorney Ohiku.
Yeah, he's a party to a crime. Yeah, he's definitely a party to a crime. Why is he driving this person to a house at 10 o'clock when he sees the person pull out a crowbar? Is he still thinking that it's a friendly visit? And then he shares in some of the proceeds. He gets money, from his friend. So yes, he's party to a crime. I think he should have known context clues should have told him that something was up, with this situation.
Mm-hmm. Attorney Patterson, what do you think? At what moment did John become a party to a crime?
I would say probably when he saw him walking to the door and pull out that crowbar. Like, that's not a normal way you enter a door. So I would say I would have, hey, come, what are you doing? Let's go. So I would say that's definitely where I think he went wrong.
Okay. Kim, what do you think? What should John have done instead in order to not be a party to a crime?
Well, as soon as John seen him pull out the crowbar, John should have left and then he wouldn't have been involved. But again, as I stated in my earlier example, he should have gone to report that, because if you're not reporting it, that's making you still involved because you knew what was happening.
Mm-hmm. Okay. Well, thank you, Attorney Ohiku, Attorney Patterson, and Kim. This concludes our OJO Q&A for this week with special guest Kim Malone. Stay tuned for next week, where not only Kim will be joining us again, but we'll be opening up the discussion to my fellow students at Marquette University Law School. Thanks for watching.